competition. My name is Julia Weston, and I'll be the bailiff for tonight's round. And in the name of ITLOS, I would like to thank everyone, all the teams, the judges, and our case authors for making this competition possible. And since this is the final round, which is being streamed live on our YouTube, I will present both our teams and our judges for today's round. So the team representing the applicant, which has been known since the beginning of the competition by its team letter O, is actually the Brazil-based Federal University of Uberlândia, UFO. And representing the respondent tonight, known since the beginning of the MOOT court as Team H, is actually India-based OP Jindal Global University. And regarding our judges tonight, who were so kind to accept our invitations to judge our final round, we have Ms. Raquel Soto Sanchez, who is a PhD scholar of the National Council of Science and Technology of Mexico at the University of Kobe, and she pursues her PhD in Public International Law in the Law of the Sea. We also have Ms. Ekaterina Nsigina, who is a postdoctoral researcher in international law at the University of Hamburg, and Mr. Carlos Cruz Carrillo, who is a PhD fellow at the University of Basel. So without further ado, I will give the word to Judge President Cruz to carry out today's final rounds, and good luck to all of our teams.
Thank you very much, Madame Lagrafia, for this introduction. Welcome everyone to the final round. The tribunal is now in session in the case concerning marine pollution in the Pacific Ocean between the Federal Republic of Makar versus the Gelder Islands. The facts of the case are well known before this tribunal, so we kindly ask to the teams to commit themselves to expose the arguments. And I would like to ask now the applicant to please present its arguments. I call therefore the first counsel of the applicant position. Please introduce your delegation and please let us know the time allocations for your pleadings, and therefore you can start making your case. The floor is yours, please.
Thank you, Your Excellency. So good evening, Your Excellencies, Mr. President, may it please the court. My name is Esli Miranda, and I appear in this matter on behalf of the applicant, Gelder Islands, together with my co-agent, Tiago Diniz. I'll be speaking for the next 18 minutes, addressing pleadings A and B. Then Tiago will be speaking for 19 minutes, addressing pleadings C and D. And finally, I would like to reserve 3 minutes for rebuttal. I divided pleading A in 2 parts, which are: first, Makar breaches its UNCLOS obligation to preserve the marine environment, and second, Makar breaches international law due to the non-monitoring of migratory species. So moving to the first part of the first pleading, the obligation to preserve the marine environment under the United Nations Convention on the Law of the Sea. The state of Makar is a small state situated in the Pacific Ocean, and it has a high population density and low recycling basis. And therefore, it relies mostly on landfills, which are poorly managed, and consequently, part of the waste is washed into the sea, as informed on paragraph 3 of the Statement of Facts. So Makar does not manage its landfills in a sound manner, neither are the seedings adequate. And because of the growing amount of plastic being washed ashore, special areas are polluted, marine species endangered, and fishing activities are unfeasible because of the poor quality and quantity of fish, as stated in paragraph 6.6 of the case. Moreover, it is also mentioned in this paragraph that Makar's marine environment is considered an ecologically or biologically significant area by the United Nations Convention on Biological Diversity. Thus, Makar violates UNCLOS' obligation to protect and preserve the marine environment as stated on Article 237 and Article 194 for failing of its obligation of stating measures to control and reduce pollution in the marine environment, Article 207 and 213 for not soundly managing its land sources, and Article 195 for transforming one type of pollution into another, failing again to protect the special areas and the biological diversity. Therewithal, MACAR also violates an obligation of end.
Agent, if may I, what is the relevance that the area in dispute is of relevance of particular relevance biodiversity for this case?
Your Excellency, the whole case is binding on the Pacific Ocean, but it only in the Rainbow Reef and waters under MACAR jurisdictions, and it only goes to EZ. So we did not formulate on the high seas in this case. And considering this fact, when I say that MACAR is violating MARPOL, it's also violating an obligation of end, since the Article 192 asserts an obligation to preserve the marine environment, reinforced by the Permanent Court of Arbitration on Article paragraph 941 in the South China Sea case as a positive obligation.
Agent, the awards from the Permanent Court of Arbitration are only binding among parties. So in which basis are you citing the award of the South China Sea for your case?
Your Excellency, using a case of the South China Sea of the PCA is not only a way of how other courts have dealt with this obligation, dealt with the problem and the issues and the marine environment as the one we're dealing on this case now. And when we consider the PCA and the South China Sea case, we can see how the other courts address these issues on the marine environment, and then we can address it for the present issues. So, Your Excellencies, it is important also to mention that the Gada Islands is not only the main contributor to the Pacific Regional Environmental Program, which is directed to paragraph 5, and it's also directed. Yes, Your Excellency.
Before you continue with your argument, I will just want to ask you a question related to the South China Sea arbitration and your line of argument regarding the obligations to protect and preserve the environment. You mentioned that it's an obligation of result. However, it is true that this tribunal has also considered that the obligation to protect and preserve the environment enshrined in Article 192 and 194, it comprises also the obligation to have due diligence. And in this regard, we are aware, or the tribunal is aware, that the respondent state has indeed took some measures in order to reduce or to mitigate a certain limit under its capacities, the environmental damage, that is to say, for example, the actions following the Delphine Agreement. So how, or can you let us know which standard we should look at to determine that the obligation that the respondent state breaches obligations within part 12 of UNCLOS? Because it's not clear for us whether you are talking about an obligation of conduct or an obligation of result. So can you just please clarify in the light of the South China Sea arbitration that you're quoting?
Yeah, Excellency, thank you for the question. So we are mentioning and addressing both types of obligations, obligation of conduct and an obligation of end. An obligation of conduct, when I mentioned the articles which are formation 237, 194, 207, and 213, which all address to the conduct of the state and the way to introduce measures to protect the environment and also preserve the biological diversity. But the Article 192 asserts an obligation of end because it's directed to the preservation of the marine environment. And this provision is also considered, as I mentioned, as a South China Sea case on the paragraph 941, when they also mentioned it's a positive obligation. And I believe that you also asked why the importance of this case, of the South China Sea case for us. So the South China Sea case basically addresses all the points we are addressing on this case between Gada Islands and MACAR as well, such, for example, specifically on fragile ecosystems, which you consider the Rainbow Reef, and also when it comes to fishing and traditional fishing, when it comes to the fishing from Philippines, and also it considers, for example, the migratory species and the conservation of these bodies. And all of these provisions I will be mentioning during my speech, and they are all following with the paragraphs they mentioned. So it's also important, Your Excellencies, when you come back to this case, that the Pacific Regional Environmental Program it is directed only to minimize land and base source pollution. And also, this program has secured $3 million only to reduce this kind of pollution, and MOCAR is a part of this program. So when it comes to vessels waste, the Pacific Ocean is also recognized as a special area under MOPAR Annex 5 Regulation 1. And the Regulation 5 of Annex 5 of the same convention stipulates the adoption of specific mandatory procedures to prevent incorrect disposals from vessels and reception facilities, which are recognized and being mentioned on the page 9, third bullet point, that MOCAR does have these reception facilities in place. And we consider this the Gabi-Duchovna-Guimarães project case, which also involved the International Boundary Water Course, which is called the Danube River. The court stressed the importance of vigilance and the prevention of vessels' activities due to their visible character of most cases related to environmental disasters and the hardness of implementing those measures, reparation measures. And considering those aspects, MOCAR is not only violating MARPOL, but it's also being omissive with its responsibilities to the marine environment, as aforementioned in Article 2 of the draft articles on state responsibilities. So moving to my second part of the pleading, MOCAR breaches international law due to the non-monitoring of migratory species. So in paragraph 6.6 of the case, it exhibits that the Pacific Ocean has high biodiversity, and it's also home to highly migratory species such as tuna and swordfish, and they depend upon strict and urgent conservation measures, according to the paragraph 7b of the Convention on Biological Diversity. So also both states have ratified the fishery access agreements regarding rules for fishing in waters under MOCAR jurisdictions, and to prevent the scarcity of fish stocks in these areas, the maximum sustainable yield rule present on Article 61, paragraph 3 of UNCLOS have to be to enable fishing for future generations and respect the principle of intergenerational equity. And those scientific information, especially about the migratory species stocks, as claimed on Article 64 of UNCLOS, have to be shared. Yes, Your Excellency.
What will imply the principle of intergenerational equity, or what should we consider when assessing this principle for the purposes of your argument?
Your Excellency, in this case, we consider the principle of intergenerational equity as important because we're talking about the impairment of fish that can be considered if MOCAR does not implement this basis on the EEZ. And also a case which mentioned that was whaling in Arctic between New Zealand and between Japan and Australia, and also involving New Zealand, and whether they mentioned about the principle of intergenerational equity as an important source, since the whaling activity was putting in risk all the lives of whales, and furthermore, the principle of intergenerational equity.
Are you sure that the ICJ expressly referred to this principle as the intergenerational equity principle? Because it seems to this court that this tribunal that was not the case. But nevertheless, I follow your argument at some point. I could agree. However, when I was looking at what my question was, is there already a standard developed by any court, either international or regional, to determine when the intergenerational equity principle has been breached?
I'm sorry, Excellency, could you please reformulate?
Yeah, sure. So following on the intergenerational equity principle, is there any standard already framed by any court or tribunal to determine when this principle has been breached in terms of conduct, or how do you determine that this principle was breached in this case, for example?
The principle of intergenerational equity is a source of international law according to the statute of the International Court of Justice and the Article 38.1d, since it's a principle, and it's binding when I use it on the whaling case, which involved in New Zealand and Australia and Japan. In this case, when they mentioned that principle of intergenerational equity is important to consider and guarantee sources for the future generations. And it's also, I hope I have fulfilled the question.
Yes, please proceed.
Yeah, thank you.
Agent, one question. You are citing the CBD Convention. On which legal basis or how is related with UNCLOS Convention and the provisions that you claim the respondent has breached?
Your Excellency, we use the Convention on Biological Diversity because the Convention on Biological Diversity addresses to the conservation of living resources and the biodiversity present on the areas we mentioned. And
But
because
also the UNCLOS Convention has expressed provisions regarding the protection and preservation of the marine environment. So why this tribunal should I also look at the CBD Convention and apply it?
because CBD, first of all, CBD, the Convention on Biological Diversity, addresses further points on the conservation of biological diversity, which I mentioned. They're also used, for example, in the Southern Bluefin tuna case, where the arbitral tribunal addressed that the conservation measures, they are made of urgency to prevent the impairment of fish stocks in the marine environment. And the Article 7B of the CBD addresses specifically that the states whose nationals fish in the EEZ, and that the measures have to be strictly strictly opposed to the conservation measures on the EEZ and on archipelagic waters. So this arbitral tribunal, like I mentioned, also mentioned that urgency to prevent impairment of fish stocks. And because of that, MACAR is not only breaching Article 7B of the CBD, which I mentioned, but also Article 61 of UNCLOS and the principle of degeneration.
Yes, I have a question. Is there any difference in the obligations that you just referred to for different types of maritime zones, and what kind of maritime zone are you considering right now?
Your Excellency, it's not that there is a difference between the zones, because, for example, the maximum sustainable yield, which I mentioned, is only applicable to the EEZ. But at the same time, if we consider this is being applied on the EEZ, we also have good consequences for the other areas of the marine areas. So, for example, really recently, the president of Ecuador, COP26, mentioned the conservation measures to be applied on Galapagos to control the transit of species in the EEZ, and they also have a positive consequences for the other areas. So introducing conservation measures have positive consequences for the other areas as well, not only for the rainbow reef, but also for the EEZ. And
are there any provisions in the UNCLOS for the internal waters, archipelagic waters, requesting conservation measures by coastal state?
Yes, Your Excellency, since UNCLOS is divided and the open seas and the EEZ, the contingency zone and territorial seas, the rules are different, and that's why we're exactly directing the rules only for the EEZ and the archipelagic waters, since this is the area we are mentioning on the speech. And if there are no further questions, I would like to move to the pleading B, which is also divided into parts. The first, MACAR failed to meaningfully consult the applicant regarding conservation measures to be applied. Since these conservation measures are open on Article 9 of the FAA, MACAR notified the other islands by an official letter, but it did not meaningfully consult the state about the negative consequences for the fishing opportunities being reduced. And ITLOS has expressed the consultation between parties and the Article 300 of UNCLOS and Article 26 of Vienna Convention of Treaties, forwarding their duty to cooperate, and they must be made in good faith. And ITLOS also reinforced by the Sub-Regional Fisheries Commission that substantial effort should be made by all states concerned. Also, the construction of a road in Costa Rica, the ICJ explained that the notify and consulting in good faith with the potentially affected states what is necessary to mitigate or determine the appropriate measures to prevent or mitigate a risk in the area. So both courts, they are very clear on the importance of cooperation, as well as separating notification of consultation in different meanings. And
also, just a little request, could you please just slow down a bit, or just
yes,
now? Calmly and continue. Thank you.
So regarding this ICJ's interpretation, MACAR notified the other islands, but did not examine together the consequences for the other states' fishing activities, electing to act due diligently and failing to solve the dispute under the Article 7 of the FAA, and also violating international law under the FAA, ITLOS, and ICJ's jurisprudence. And also, MACAR failed to cooperate with the other islands, since Article 199 of UNCLOS asserts that all states in the affected area shall jointly develop, promote, and contingency plans to respond to the pollution incidents in the marine environment. as affirmed also in Article 61, 64, and on Article 5 of the CBD. And the coastal states and other states whose national fish in the region shall cooperate to ensure the maintenance of the living resources and also of the highly migratory species, as well in a mutual interest of the conservation and sustainable use of the biological diversity. These provisions reinforced by ITLOS on the MOOT plan.
Sorry, now a question on the duty to cooperate. So it comes for the attention to this tribunal that the respondent states it's indeed deploying all the means that it has under its capacity. And when you are talking about the duty to cooperate, we are failing to see here at the moment, unless you clarify, how your state is also cooperating to protect and preserve the marine environment under the analysis of this case. Because it seems that on the one hand, the respondent has limited resources because of its limited capacity and infrastructure to develop better manners to tackle marine pollution, whereas your country is one of the main producers of plastic pollution, which under the facts of this case are provided to the respondent state. So in this regard, how your country is also complying with this obligation to cooperate, because it seems for us that everything is in charge of the respondent state at the moment, but we also have that we are aware of their limited capacity. So how do your state is fulfilling this obligation to cooperate?
Your Excellency, my time is up. So if I will be addressing your question, I need additional time.
Please, you have 30 seconds to briefly.
Okay, so it's a long
answer. You have 1 minute and we will be.
Thank you, Your Excellency. So basically, Gilda Islands is asking MACAR to cooperate because we as Gilda Islands have cooperated already when it comes to the prevention of pollution in the marine environment. For example, the Pacific Regional Environmental Program is a program which has a fund of $3 million, and the main contributor is Gilda Islands. And also Gilda Islands has the Green Fund, which is present on paragraph 4 of the case, mentioning that the Green Fund is responsible for many cleanups and also recycling bases and the creation of bio-based plastics. And also, for example, the Green Fund is, Gilda Islands is asking all the fishermen on the region to come back with their fishing nets, so they are paid back for the fishing nets brought back to land. So this is, for example, an instance on how Gilda Islands is dealing with the pollution. And when we come to MACAR has not done much when it comes to the pollution in our environment. And the only things we can address on the statement of facts, they're actually listening that MACAR has held coastal cleanups and such things, but they are all led by civilians or led by non-governmental organizations and not led by the states. So that's why.
That will be all, your counsel, please. Thank you so much for the answer and for your presentation. Madame Lergafier, how much time did we allocate for this speaker in extra time?
1 minute.
Okay, perfect. So the respondent may use 1 minute either in the speaker 1 or the speaker 2. I will now call second counsel of the applicant to start pleading his case.
Good afternoon, Mr. President, Your Excellencies, agents for the respondent. My name is Thiago Diniz. I'm the second agent for the applicant, and I'll be exposing the 2 last pleadings for the next 19 minutes. May it please the court. Your Excellencies, concerning the third pleading, the applicant asked the tribunal to note that MACAR fails to recognize the Gilda Islanders' fishing rights. The preamble of the Fishery Access Agreements recognize the indigenous people of the Gilda Islands' traditional fishing activities around the Rainbow River. In addition, Article 2 requires MACAR to authorize the fishing activities made by the Gilda Islands vessels in its waters. Moreover, Your Excellencies, the importance of the recognition and protection of the traditional fishing rights are settled by UNCLOS in its Article 51. It provides that states shall recognize traditional fishing rights, and other legitimate activities of the immediately adjacent neighboring states. Furthermore, consider that the rules concerning the traditional fishing rights shall be regulated by bilateral agreement. The importance of this article was recognized by the South China Sea Arbitration of 2016 in its paragraph 804. And for that matter, I'd like to emphasize that the Gelderlanders' traditional fishing rights are recognized by a bilateral agreement, the Fishery Access Agreement.
I have a question about the commercial character of rights that you're referring to, that, well, is a case of concern of Makar. Can you address?
Thank you for your consideration, Your Excellency. Firstly, Your Excellency, I'd like to ask you to follow the paragraph 6.1 of the text. In this paragraph, it's clear that the main activity carried out by the Gelderlanders are traditional, and it exists for the benefit of their livelihood. And the exportation of the productions in the Rainbow Reef are just recently made and does not constitute the main activity carried out in the region, Your Excellencies. And it demonstrated in the dispute between Eritrea and the Yemen in its paragraph 526 that states must respect, preserve, and ensure traditional fishermen's activities for the benefit of their livelihood. And as Yemen in that situation, in the present case, Makar is required to respect, preserve, and ensure these traditional activities of the Gelderland. Your Excellencies, it's also important to highlight that the South China Sea Arbitration also demonstrated the importance of this provision in the paragraph 259 of the case. And moreover, the same case considered that the fishermen's activities constituted a vested right, and the tribunal considered that the rules of the international law on the treatment of the vested rights of foreign nationals to fall squarely within the other rules of international law applicable in the territorial sea. Another very important case, Your Excellency, the Chagos case, in its article 456, considered the importance of the insurance of the traditional fishing activities of the communities over the territorial waters of another state. And in the sense, this tribunal shall recognize that Makar is required to respect the activities carried out by the Gelderlanders around the Rainbow Reef. So, Your Excellency, in this sense,
I have another question. Sorry.
Yes,
should this obligation change if circumstances change, such as climate change, stock collapse, increased activities of own population, and so on?
Thank you for your consideration, Your Excellency, but please could you rephrase it?
Yes, let's say there is less fish now in the areas concerned. Should the obligations of Makar be adjusted or changed if there are circumstances requiring that?
Thank you, Your Excellency. And yes, Your Excellency, the Fishery Access Agreement could provide it, but the applicant respectfully asked the tribunal to note that the obligations of Makar with the traditional people of the Gelderlanders shall prevail, Your Excellency. And it's something that has been demonstrated in the World Trade Organization decision concerning the importation of seal products of 2014. And the World Trade Organization decided that indigenous communities' activities should be protected once it constituted this people tradition, contribute to their livelihood, and respect animal welfare. In this sense, Your Excellency, Makar is required to respect the traditional activities carried out by the Gelderlanders around the Rainbow Reef. And another relevant information present in the fact, the paragraph 6 of the facts, Your Excellency, is that Makar is increasing its efforts to become the Rainbow Reef into a tourism destination. Article 194 of UNCLOS provided that in taking measures to control marine pollution, states shall refrain from unjustifiable interference with activities carried out by other states in the exercise of their rights. And Your Excellencies, it is possible to note that the measures taken by Makar to control pollution in the region has an economic background, and the main reason for the action is not the preservation of the marine environment. In this sense, the applicant requests the tribunal to note that Makar also breached Article 194, paragraph 4 of UNCLOS. Your Excellencies, alternatively, Makar violated international law in not consulting the Gelderlanders concerning the measures that it wants to take. Your Excellencies, as we can see in paragraph 6.1 of the facts, the Gelderlanders fishing activities are made under Makar's jurisdiction. In the sense, considering the Fishery Access Agreement in its Article 9 provides that consultation must be held between the parties. And Your Excellencies, Makar is the one which should have made consultation to the traditional people of the Gelder Islands before introduce conservation measures.
Have they introduced any act?
Your Excellencies, the Makar, it is possible to be seen in paragraph 6.7 of the text. Makar issued a letter requesting the immediate ceasing of the fisheries activities carried out by the Gelderlanders, the traditional people of the Gelder Islands around the Rainbow Ridge. And Your Excellencies, concerning the traditional activities, the Inter-American Court of Human Rights in Pueblo Samaca case, paragraph 131, and Pueblos Calinha y Locono case, paragraph 122, both against Suriname, recognize the importance of the participation of traditional peoples in decisions which affect their livelihood. This is also
excuse me, I'm losing you because I'm not following your argument. You are saying that the Gelder Islands have traditional fishing rights in the area of dispute of the Rainbow Reef. But then you say that the vessels of the Gelder Island go there to exercise their traditional fishing rights. But then you mentioned that it's the indigenous people of the Gelder Islands that have the traditional fishing rights. So is the indigenous people in charge of the vessels that exercise fishing, and to what capacity they are conducting fishing activities just for the livelihoods? And in this sense, the Inter-American Court of Human Rights is a regional organism. On which basis are you bringing those rulings on human rights before this tribunal?
Thank you for your questions, Your Excellency. And firstly, Your Excellency, the Gelder Islands vessels have the right to fish in Makar's waters as provided by Article 2 of the Fishery Access Agreement. And the preamble of the same agreement provides that the Gelderlanders has traditional fishing rights to explore the region, even if it is over the Makar's jurisdiction. And Your Excellency, the importance of the Inter-American decision to the present case is something that we should note, because the decisions of international courts are recognized by the Article 38(1)(d) of the Statute of the Court as source of international law, Your Excellencies. It's important to note that the Inter-American Court uses this document to demonstrate the existence of a comprehension about the importance of consultations concerning measures which affect indigenous people. And in this sense, it constitutes a ratio dissidenti which considers the necessity of consultation. In the sense, Your Excellencies, the applicant request.
But in any case, the consultation should be organized by your country itself, because the obligation to consult, it comes in an interstate level, right? So the respondent should first consult with you, and therefore you as a state where the indigenous communities are located has perhaps the responsibility to conduct these consultations under Inter-American guidelines. So how does this perhaps change your argument or not? Can you just clarify this aspect of whether you have the obligation or not?
Thank you, Your Excellency. Concerning the consultations between the states, I believe my co-agent has already stated in her speech, and in here the argument is that Makar was required to consult specifically the Gelder lenders, and we have shown these considerable sources of international law to prove that Makar has this obligation to consult the Gelder lenders.
Precisely, that was my question, because I'm failing to see whether Makar has a direct obligation to consult the islanders particularly. I think the obligation is with your country. So perhaps therefore, after you receive the consultation from the respondent, then you will conduct the consultation with the Garden Islanders, right? Or could you just clarify that aspect?
Thank you for your question, Your Excellency. But the applicant respectfully asked the tribunal to note that the applicant has shown considerable sources of international law, which proves that the state of Makar is required to make consultations to the Gelderlanders, considering that the Gelderlanders' activities are carried out under Makar's jurisdiction, Your Excellency.
Agent, I have here, following my colleague, yes, it might be correct what you are saying, but how does that, it's a competence of this tribunal to look at? I mean, the consultations might be right under international law, but is that a competence of this tribunal to look at? And it seems to me that you're referring to all the Gelderlanders people as indigenous people. All the Gelder Islands people are indigenous people, and the UNCLOS does not have any specific provision regarding indigenous people. How this tribunal has the obligation and most importantly, the competence to rule regarding indigenous people's rights?
Thank you, Your Excellency. And in the paragraph 6.1 of the fact, we can note that the Gelderlanders are specifically the indigenous people of the Gelder Islands. And I respectfully ask Your Excellencies to note that Article 51 of UNCLOS consider the importance of the traditional peoples and their fishing activities rights. And that's the reason why this tribunal should make decisions considering this point, Your Excellency. It is provided by Article 51.
You cite, you refer to the Inter-American Court of Human Rights rulings that it is important, the rights of indigenous people. That's correct, but the UNCLOS, as you mentioned, recognize the rights of traditional fishing rights. But why you stress the fact that it's indigenous people rights? Because it seems that the specificity of the case on indigenous people rights is not within the competence of this tribunal.
Thank you, Your Excellency. But the applicant respectfully asked the tribunal to note the importance of the ITLOS to adjudge this case, considering that both decisions of the Inter-American Court constitute as part of the sources of international law and should be accepted by this tribunal as prescribed in Article 38(1)(d) of the statute of the court, Your Excellencies. Your Excellencies, if there are no further questions, I'd like to move on to my next pleading and ask the tribunal to adjudge and declare that the Delphin Agreement breaches East Cogan's rule and is consequently void under international law. Your Excellencies, the United Nations Security Council has decided under Chapter 7 of the UN Charter, the Resolutions 2457 of 2019 and 2584 of 2021, and decided that there is a very important relevance of socioeconomic infrastructure development and industrialization for the regional peace maintenance. And considering paragraphs 1, 4, and 6.1 of the facts, it is possible to note that the Gelder Islands are the main economic regional power of the region. And the defeat of the applicant's economy could represent a threat to the regional stability and peace maintenance. In this sense, Your Excellencies, the International Court of Justice has already decided in the case concerning the military and paramilitary activities in and against Nicaragua, paragraph 190, that the peace and security maintenance constitutes a jus cogens rule. Consequently, Your Excellencies, in breaching a jus cogens rule, the Article 53 of the Vienna Convention was also breached. In this sense, the Delphin Agreement should be considered void under international law. However, even if the tribunal... Yes,
can you please clarify how the Delphin Agreement threatens peace and security in the region? Like
yes,
what particular provisions?
Thank you for your question, Your Excellency. The applicant considered that the Article 2 of the Delphin Agreement threatens the Galder Island economy, and the United Nations Security Council has established that economy and industry are a basis for the regional peace maintenance in the resolutions 2457 and 2584, Your Excellency. In this sense, considering that the ICJ has decided that peace and security constitutes a jus cogens rule, it breaches a jus cogens rule and must be declared void under international law, considering Article 53 of the Vienna Convention. But, Your Excellencies, even if the tribunal finds that the Delphin Agreement is not void under international law, it does not create any obligations over the Galder Islands, Your Excellency. Exercising its right, the Galder Islands did not verify and in any event can be liable by obligations which arise from the Delphin Agreement. And the binding of the Delphin Agreement over the Galder Islands could represent a violation of the Pacta Tertis nec nocent nec prosunt principle. According to Professor Zanella, the Pacta Tertis principle provided that no state can be liable for a treaty that was not signed by it. And Your Excellencies, in case numbers 21 of ITLOS concerning the advisory opinion of November 28th, Argentina has argued before the tribunal considering the Pacta Tertis principle. And also case number 16.
One question, sorry to interrupt you. On which do you consider that this tribunal has competence to declare the Delphos Agreement void?
Yes, Your Excellency, thank you for your question. The United Nations Security Council has determined in its resolution 478, paragraph 3, that all legislative and administrative measures and actions taken by Israel concerning the character on the status of Holy City of Jerusalem are null and void. In this sense, Your Excellencies, if no tribunal of international law having ever decided that a treaty is void, the applicant believes that ITLOS could declare it void, Your Excellencies. But even if it's not void, the binding of the Delphin Agreement could, Your Excellencies, may I have some seconds just to finish my pleading?
Please, you have 30 seconds.
Thank you, Your Excellency. And just to finish, the binding of the Delphin Agreement breaches the Pacta Tertis principle. And in this sense, the applicant requires the tribunal to adjudge and declare that Makar breaches its obligations to protect and preserve marine environment, that Makar fails to recognize the tradition of fishing rights, and finally, that the Delphin Agreement is void, and even if it's not void, it does not create any obligations over the Galder Islands. May it please the court.
Thank you, counsel. Thank you to the applicant state for its exposition. I call the respondent state to start pleading its case. Therefore, I called the agent of the respondent to please introduce its allegation and let us know the allocation of time for your arguments. Respondent 1, please, you have the floor.
Thank you, Your Excellency. I apologize. Honorable members of the International Tribunal of the Law of the Sea, opposing counsel, and everyone present at this hearing today. Good evening from where I stand. My name is Smruti Bhutada, and my co-agent Aishwarya Ala and I will be representing the respondents, the Republic of Makar. I will be speaking for the next 20 minutes with my co-agent Aishwarya, who will be speaking for 18 minutes. We respectfully reserve 2 minutes for rebuttal. The applicants have submitted before the judges that the Makar that Makar has breached the fisheries access agreement, that Makar has failed to evade all responsibility for proper waste management and due diligence, that Makar has unreasonably and arbitrarily adopted conservation measures, and that an agreement attempting to improve the waste management solutions within the region is a threat to the applicants. This is an attempt by one of the most economically developed countries in the Pacific region to undermine a developing countries, that is Makar's genuine attempts at conserving their marine environment. In stark contrast to what the applicants have argued, the respondents would like to make the following submissions. First, we contend that Makar has in fact complied with the fisheries access agreement. Second, that is, the Gelder Islands has failed to respect Makar's rights under the under the archipelagic state and the EEZ regime. Third, that the Gelder Islands has flagrantly violated their obligations under international law to protect the marine environment of Makar. Fourth, that Makar's waste management solutions are consistent with international law. And finally, that the standards emanating from the Delphin Agreement are binding upon the Gelder Islands. I will be covering the first three submissions, while my co-agent Aishwarya will be covering the last two submissions. Coming to Makar's compliance with the Fisheries Access Agreement. According to Article 1 of the Fisheries Access Agreement, the rules governing the fishing activities of vessels flying the flag of the Gelder Islands in Makari waters will be set in accordance with international law. It is pertinent to stress on the phrase in accordance with international law when we consider the following arguments. In the southern bluefin tuna cases, this tribunal observed that the conservation of living resources of the sea is an element in the protection and preservation of the marine environment. Echoing this observation are the codified obligations on all states under Part 12 of the UNCLOS, specifically Articles 192 and 194, to protect and preserve the marine environment. Through a reading of Article 42.1 with Article 54 of the UNCLOS, an archipelagic state may adopt laws and regulations relating to the prevention of marine pollution. As mentioned in Para 2.5 of the written submission submitted by the respondents, multiple articles of the UNCLOS discuss the duties of a coastal state. These include Articles 56, 63, 64 of the UNCLOS. Similar obligations arise under Article 7 and Article 17 of the Fish Stocks Agreement. Coastal states have, as elucidated by myself earlier, an obligation to conserve and protect the marine environment and take measures to prevent and reduce marine pollution under international law. To this effect,
did you effectively prevent pollution from land and from other sources in your waters?
Thank you for your question, Your Honor. As will be argued by my co-agent in her submissions, Makar has done all its due diligence measures to ensure that they attempt to have the required waste management solutions to their economic capabilities, as will be elucidated by my co-agent further. They have done their obligation to ensure that they, to the extent of their economic capabilities, incorporate the correct waste management measures to that effect.
So you imply that your status as developing states actually influences your obligations to protect and not to pollute.
I apologize, Your Excellency. Could you rephrase your question?
So you are implying that your status as a developing state actually influences your obligations not to pollute the marine environment and to protect marine environment. So you have less obligations than other states.
In so much as that, Your Excellency, Makar has a slightly altered threshold of responsibility towards its marine environment. And we point that out to the fact that regardless of socioeconomic status, I apologize. Our waste management solutions are consistent with Makar's status as a small island developing state, even taking into consideration that the Pacific Ocean is a special area. Articles 207 and 211, for that example, explicitly state that all preservation measures should be considered against a nation's economic capacity and regional features. Makar is vulnerable in both aspects. Article 207 of the United Nations UNCLOS Convention on the Law of the Sea places an obligation on states to prevent, reduce, and control pollution to the fullest possible extent, read with the responsibilities and obligations of states with respect to activities in the area rendered by the International Tribunal for the Law of the Sea. It states that an obligation to comply with such a duty is greater for developed states than for developing states. This implies that the standard for MACAR's waste management solutions must take into account its socio-economic development goals. If I may be allowed to continue, Your Excellency. Yes. MACAR's setting up of rules regarding fishing activities of the Gelder Island vessels in accordance with international law, specifically the international law obligation to conserve the marine environment, is conforming with Article 1 of the Fisheries Access Agreement. Article 9 of the same agreement states that if MACAR decides to introduce conservation measures which would affect the Gelder Islands, consultations shall be held. The applicants have referred to the judgment in the Nicaragua versus Costa Rica case to present that both notification and consultation in good faith are required under due diligence obligations. While the question about the notification is not contested, with specific regards to consultations in good faith, the applicants contend that there is a lack of good faith consultation by MACAR, given the failure to resolve the dispute in the one negotiation that occurred between the parties. It is pertinent to note, however, that in Ghana versus Ivory Coast, the tribunal noted that an obligation to consult is an obligation of conduct, not one of result. Even if the one negotiation did not meet the Gelder Islands' expectations of a settlement that they should have derived out of that negotiation, the act of meeting for the negotiation implies good faith from MACAR's side, and MACAR's actions have been in accordance with Article 9 of the Fisheries Access Agreement. Even if this tribunal were to find MACAR's consultations not in good faith, the argument made by the applicant is one of due diligence. The Seabed Dispute Chamber, in its 2011 adversary opinion, opined that due diligence is a variable concept and may change in relation to risks involved. The standard of due diligence is much severe considering the riskier activities. In this case, a question begs to be asked. What is this? I apologize.
Counsel, are there any obligations to balance rights of MACAR and Gelder Islands?
Yes, of course, Your Excellency, there are obligations to balance rights.
So in introducing any measures, should you actually consider rights of Gelder Islands? Did you do that?
Yes, Your Excellency, we should consider the rights of the Gelder Islands, and we did do that in our reference to consultation. With regards to the specific rights, the traditional fishing rights of the Gelder Islands, as will be expanded by myself further, we contended that the activities done by the Gelderlanders does not constitute traditional in the definition that was given by the Eritrea versus, not exactly the definition, but the standard in the Eritrea versus Yemen arbitration. And given that these rights also encroach upon MACAR's sovereignty, there is a question of whether MACAR should continue respecting these rights. And as will be argued by myself further, it is not the case. If Your Excellency would like me to continue. Yes. Even if the tribunal were to find MACAR's consultations not in good faith, the argument made by the applicants was of due diligence. The Seabed Dispute Chamber, as I have already previously mentioned, said the standard for due diligence has to be more severe in case of riskier activities. So in this case, a question begs to be asked. What is the standard of due diligence the applicants urge the tribunal to apply in a case where the risky activity is the act of adopting conservation measures to prevent harm to one's environment? We thus maintain that there has been no breach of the Fisheries Access Agreement. The next submission is that the Gelder Islands has failed to respect MACAR's rights under the archipelagic state and its EEZ regime.
Can we go back a bit to the previous one? So don't you think that your measures are discriminatory because they actually prohibit some fishing practices that are employed mostly by Gelder Islands vessels? So you basically discriminate Gelder in your waters in order to I don't know, give more benefits to your own vessels?
I apologize. If I may rephrase your question, you're referring to the fact that we are imposing fines upon foreign vessels with regards to the pollution and that it is discriminatory in that sense? Is that what Your Excellency is contesting?
No, I'm referring to fish and aggregating devices which are deployed by Gelder Islands. So you're basically excluding practice, a particular practice in your water.
With regards to fish aggravating devices that have been deployed by the Gelder Island vessels, it is very pertinent to note that in para 6.7 of the facts, these fish aggravating devices are not deployed keeping in mind that they have to be done with due diligence. In fact, it is noted that they often lose their anchor and come adrift. They have been actively polluting the waters of Makar, and it is Makar's right to conserve the same, since it is Makar's waters in the end. As mentioned earlier, the UNCLOS and the UN Fish Stocks Agreement place certain obligations upon Makar with respect to adopting preventive and conservative measures. Makar has done the same. The Gelder Islands have essentially, as I have mentioned regarding the fish aggravating devices and even the ghost nets, if Your Excellencies could refer to para 7. If Your Excellencies could refer to para 7.1, the Makari authorities have proof that the fish nets that have washed ashore on the Makari coasts are made of bio-based plastics. These plastics are derived from algae, something which is done by the Gelder Islands. And
I have a question. Is it possible that your vessels purchased nets from Gelder Islands and just use them too?
Thank you, Your Excellency. With regards to that, we would like to draw attention to paragraph, I apologize. We would like to draw attention to paragraph 4 of the case fact submission, which says that the Green Fund, through researchers and companies, has attempted to commercialize recyclable plastics and biodegradable plastics. But to that effect, there has been no indication of whether these have been supplied to other countries as of now as well. And given that Makar right now only imports, it's dependent on food and water imports specifically from the Gelder Islands. It's a small island developing state with limited economic capabilities. The proof conclusively does point towards Gelder Islands. It is the Gelder Island vessels that have been fishing in these waters, and the authorities do believe that it is the Gelder Islands vessels that have been negligent in the way that they have been using their fishing nets, and that it is the Gelder Islands fishing nets that have washed ashore.
Excuse me, just to clarify, following my colleague's previous question. So within the waters of Makar, are only the Gelder Island exercising fishing rights, or is there other flag states fishing vessels exercising fishing rights, and you are trying to impose a express prohibition to only Gelder Islands vessels to fish within your waters? Because if it is the second case, then it would be a discriminatory measure. So just to clarify with you, are only Gelder Island vessels exercising fishing activities within Makar's waters under Makar's jurisdiction?
With regards to that, as the case facts prove insufficient to answer that question, we would like to refer to the fact that stricter fines would be applicable under the measures that Makari government have considered on any foreign vessel for any sort of plastic pollution of any kind within Makar's fishing zone, which does apply that other vessels flying the flags of other states have been fishing within the zone. And none of these facts do imply that there is a specific targeting of the Gelder Island vessels per se. So we don't understand where the idea that it's only the Gelder Island vessels that will have to adopt stricter standards to prevent losing air, or it is the Gelder Islands that will be imposed on by extremely high fines, have to suffer through the conservation measures that would be adopted by Macquarie authorities. It would be applicable to every flag state that, and every vessel of every flag state that fishes within the Macquarie fishing zone. With specific regard to Gelder Islands, because there has been a fisheries access agreement between the same, we have notified the Gelder Islands of the same and of the adopted measures that we are considering taking. Due to paucity of time, is it okay if we continue? Thank you, Your Excellency. The applicants claim that Macquarie has failed to conduct its obligation to respect traditional fishing rights within Article 51 of the UNCLOS. It is pertinent to note that the obligations under Articles 47.6 and 51.1 extend only to archipelagic waters, and these rights are not guaranteed within internal waters of the coastal states. If Your Excellencies could turn to paragraph 6.2 of the case facts, it is established that Rainbow Point lies within the line delimiting Macquarie's internal waters. The Gelder Islands cannot claim historical fishing rights within these internal waters, and by fishing in the Rainbow Point have breached Macquarie's sovereignty. Even with regards to their traditional fishing activities, in para 809 of the South China Sea arbitration, as mentioned by respected applicants, the tribunal held that traditional fishing rights constitute a vested right. These vested rights may be subject to reasonable regulations, for example, to ensure environment protection. Even so, the tribunal in Eritrea versus Yemen arbitration adjudged that industrial or large-scale commercial fishing does not constitute traditional fishing, something which is happening in this case. So the commercial character of the Gelderlanders' fishing activities precludes them from claiming these activities as an exercise of traditional fishing rights. More so, given the disrespect of Macquarie's sovereignty and the changed nature of these fishing activities, Macquarie is under no obligation to continue respecting these rights. However, it is essential to note that the Gelder Islands has failed to respect Macquarie's rights as an archipelagic state to adopt conservation measures and Macquarie's sovereignty over its internal waters. Moving on to my final submission, we contend that the Gelder Islands has violated its obligations under international law by failing to ensure that fishing vessels flying its flag in Macquarie fishing zone don't pollute the marine environment. While obligations to protect and preserve the marine environment arise on Macquarie under Part 5, Articles 61 and 64 of the UNCLOS, which Macquarie has conformed to, even the Gelder Islands has duties within the Macquarie waters. Article 192, 194.1 and 194.3b under Part 12 of the UNCLOS impose without qualification an obligation on states to protect and preserve the marine environment and to take measures consistent with the convention that are necessary to control marine pollution. If Your Excellencies could refer to para 6.7 of the case facts, you would see that Gelder Islands fish aggravating devices often come adrift, and para 7.1 of the case facts, as argued by myself further, conclusively prove that it's their fishing nets that have come ashore the shores of Macquarie. It can be observed in lights of the argument, The Gelder Islands has thus breached their obligations under UNCLOS to prevent pollution of this sort, and it can be observed in light of these arguments that the Gelder Islands is an explicit breach of its international duty to protect and preserve the marine environment. The applicant has failed to comply with their obligations under multiple articles of the UNCLOS, the Basel Convention, the Convention on Biological Diversity, the Fish Stocks Agreement, and the obligations stemming from customary international law as well. Macquarie has, in comparison, conformed with its obligations under these conventions and the Fisheries Access Agreement between the Gelder Islands and Macquarie. The applicant has also breached Macquarie's sovereignty by fishing within the territorial waters of Macquarie. They have abused their traditional fishing rights. And with this, I would like to conclude my submissions and defer to my colleague Aishwarya to discuss the other two submissions.
Thank you, Counsel. I now call upon the second counsel of the respondent state to present its pleadings. You have the floor.
Thank you, Your Excellency. Mr. President, Your Excellencies, and members of the Tribunal, my name is Aishwarya Ala, and I will be presenting the remainder of our submissions. First, we contend that our waste management solutions are perfectly consistent with both international law as well as the international law of the sea. We thereby believe that the applicant's submissions regarding the insufficiency of the same are unfounded. Secondly, I will be arguing that the Gelder Islands has violated their international obligations by not participating in the Delphon Agreement, and regardless, must still conform to the standards that emanate from it. To be as comprehensive as possible, I will be addressing the applicant's contentions issue-wise as I make our own submissions. Makar must be held to a slightly altered threshold of responsibility towards its marine environment, something I believe that my co-agent has already appraised the tribunal of. With reference to the applicant's contention about Makar's reliance on landfills, contending a violation of Articles 207 and 213 of UNCLOS, we point out that these articles also state that states must adopt measures in consideration of standards established by international organizations. Annex 3 of the Assistance to Developing Countries in Implementing the Basel Convention and in Preparing National Hazardous Waste Management Plan, which the Gelder Islands must take cognizance of by virtue of ratifying the Basel Convention, recognizes landfills as an acceptable disposal method for developing states. Small island developing states must be granted a level of consideration, as stated in the Barbados Program for Action as the only my apologies.
So I have a question. Do you say that you can pollute and Gelder Islands cannot pollute in the waters concerned?
Oh no, certainly not, Your Excellency. What we are merely trying to state is that at the end of the day, both countries are under a slightly different obligation towards the marine environment. So while it is true that neither can merely sort of throw UNCLOS out the window and pollute the environment as they wish, we do contend that the conservation measures enacted to prevent this from happening are held to slightly different standards for the reasons that I will now elaborate upon. So as I was saying, SIDS must be granted a level of consideration as stated in the Barbados Program for Action as the only international document specific to and unanimously endorsed by small island developing states, with their recommendations reflected in state practice, fulfilling the recommendations laid down by the Right of Passage over Indian Territory, which recognize that even if a set of practices are merely regional and between only a few states, that can still amount to customary law. The applicant has emphasized that Makar has refused to carry out systematic environmental impact assessments within our fishing zone and informed them about decreasing fish stocks with reference to maximum sustainable yield, as per Article 61.3 of UNCLOS. Your Excellencies, I would like to first make a purely fact-based construction. Article 1 of the FAA establishes that fishing activities must be in accordance with international law. UNCLOS Article 61.3 mandates that coastal states may decide our MSY and send that info to parties fishing in the fishing zone. The fact submission is insufficient to determine whether or not Makar has established an MSY, so this may at first seem irrelevant to the dispute. However, it is pertinent to note that in paragraph 6.3 of the facts, there has been no change in the quantity of fish that the Gelder Islands is allowed to fish with reference to the protocol specifically annexed to the FAA. As soon as Makar saw a decrease in their fish zones, Makar then informed the Gelder Islands and attempted to adopt strict conservation measures to prevent those fisheries from exhausting. The applicants in their submission mentioned that migratory species depend on strict conservation measures to prevent exploitation. The Gelder Islands, who so desperately wanted Makar to adopt conservation measures, are now contesting the same because their economic goals are now being threatened by these measures, which is not under the ambit of 61, an article with the express aim of preventing overexploitation. in accordance with UNCLOS Article 61.3, which explicitly considers the special requirements of developing states and the fact that MACAR has been enthusiastically attempting to participate in conservation under both the FAA as well as the Delphon Agreement, we refute the argument that we are in breach of the same. The responsibility...
I have a question. Are you aware about the advisory opinion on sponsoring activities in the area?
Yes, Your Excellency, I am.
That actually concluded that none of the provisions provides for the preferential treatment for developing states. Can you address this issue?
Yes, of course, Your Excellency. So if I may make reference to the same document, I'd also like to point out that in a part of it, it is also mentioned that the obligation to comply with duties of conservation is greater for developed states than developing ones. Now, this is not to say that for some reason MACAR must then be allowed to pollute the environment far more than the Gelder Islands. However, we're merely trying to say that we are not absolved from enacting these measures. We are not absolved from our responsibility to not pollute the environment. However, what must be considered, especially in light of UNCLOS Articles 207 and 211, the standard that our conservation measures and our waste disposal measures are being compared to, those standards must be at a slightly lower threshold than, for example, the Gelder Islands, who is the most developed and high income state within the area. That's what we are contending. My apologies. Thank you. So Gabchikovo Nagimaros, please excuse my pronunciation, does indeed stress the need to pay attention to vessel activities. But we further contest that the responsibility to do so does not lay with one state alone. Paragraph 78 heavily implies that the inequitable appropriation of waters from which two or more states may derive a benefit from is a breach of international law. Each state has an obligation to the protection of the same. Considering the benefits, primarily by way of fishing rights within MACAR's internal waters that the Gelder Islands has and continues to reap via the FAA, to place a sole obligation on MACAR's waste mechanisms would be inequitable. It is clear that, though the proposed waste management measures resisted by the applicant, MACAR is doing the most it can within its means, but is being blocked from doing so by the economic goals of the Gelder Islands, who is, again, the most developed nation within the region. Continuing onwards to our final submission, it is submitted that the applicant has violated UNCLOS and international law at large by not participating in the Delphon Agreement. Critical here is the duty to cooperate, enshrined in Part 12 of UNCLOS. Numerous articles already brought up by my co-agent and I, 194, 202, 207, 211, 213, all in one way or another enshrine the notion that nations must, in accordance with their economic capabilities, act through the appropriate organizations to achieve conservation aims. The Gelder Islands has refused to cooperate with the objectives of the Pacific Regional Environmental Program, hereby referred to as PREP, in direct contravention of Articles 198 to 201 of the Convention. By neglecting the fragile state of the Pacific Marine Territory and refusing to participate in measures that are specifically aimed at alleviating pollution and subsequent damage. The Delphon Agreement promotes technological cooperation and the exchange of information, which has also been enshrined in Article 10.2d of the Basel Convention. This is also echoed in the Convention for Biodiversity Articles 15 and 19, which both mandate the sharing of information between parties benefiting from the genetic resources found in one state.
And so what about the argument of the MACAR, Gelder Islands, that, well, this agreement is not applicable to them under Article 34 of the Vienna Convention, and, well, they cannot be forced to conclude the agreement?
Yes, of course, Your Excellency. So actually, this is something that I will be getting to throughout my argument. Is this something that you would prefer I get to right now?
Yes, thank you.
All right, will do. Now, the applicants would have you believe that they're not bound by the Delphon Agreement as they have been a persistent objector. Now, we submit that this rule would not be applicable in this particular case, as a state can only be considered a persistent objector to the rule of customary international law if they made their objections at the time of the formation of the rule. In the present case, the Delphon Agreement merely codified pre-existing codified international law, and the Gelder Islands only made their objections after the agreement was formed and not when the norm of the customary international law was formed. As such, they can't use the persistent objector rule.
So you're saying that there is no customary law, and while they are not persistent objector, but this agreement is still not binding for them because they're not the party. So how do you claim that it is obligative?
Oh, certainly not, Your Excellency. So actually, we contend that several of the norms that emanate from the Delphon Agreement have actually found their roots in customary international law. So as a result, we contend that the Gelder Islands, despite the fact that they have objected to the Delphon Agreement, they've only done that after the agreement was formed, but there was never a point where they had ever objected to the initial customary principles that the Delphon Agreement actually draws from in order to formulate its standards. So I hope that sort of clarifies that.
I would like, before you proceed, I would like you to clarify something for this tribunal. You have highlighted several times that the applicant is a developed country, but under international law and this forum, all the states come in equal capability and equal treatment. So on which basis and what is the relevance to highlight that the applicant is a developed country? Because you are stressing a difference between, well, what is to me a difference between the applicant and you, the respondent. So this tribunal cannot address states on different capabilities. The principle of equality among the states should prevail. So what is your basis and your rationale to highlight that the applicant is a developed country?
Yes, of course. Thank you, Your Excellency. So, Your Excellency, we contend that this is not so much a question of equality as it is for equity. So, as has been aforementioned, several articles within UNCLOS do actually make that distinction between a developed nation and a developing nation. So this is the basis of the argument we're making. Moving on to where this might have been acknowledged in actual case law.
My colleague already highlighted for you that in the advisory opinion on responsibilities, it was a state that those differences cannot be made. So,
of course.
What is your rationale?
Yes, Your Excellency. So even moving away from perhaps the codified law itself, if you could make reference to the Mox plant case between Ireland and the United Kingdom, references were made to the differing economic capacities and regional considerations that the difference between Ireland and the United Kingdom. So again, we're not suggesting that the tribunal necessarily treat Makar and the Gelder Islands differently. We're simply stating that these are considerations that we believe that we urge the tribunal to take to achieve these goals of equity that have already been enshrined and implied through cases like the Mox plant case in the past by this very tribunal. Yes, thank you, Your Excellency. We would now like to contend that the applicant's reference to pacta tertis nec nocent nec percent, again, I apologize, flows from notions of sovereignty that are further rooted in Article 34 of the VCLT. Now, we concede that this argument seems attractive as it is an established principle of international law. However, I would like to submit that this is a highly objective way of considering the maxim. and fails to take into account considerations of how sovereignty must and questions of economic development must be balanced with considerations of environmental conservation. With reference to the argument about the Delphin Agreement being void due to its violation of the UN Charter, the applicants have cited a separate opinion of questions of interpretation and application of the 1971 Montreal Convention arising from the aerial incident at Lockerbie. However, according to Article 57 of the ICJ statute, a separate opinion is delivered in case the actual judgment does not represent the views of the judge and thus has no binding power. If your excellencies would refer to the actual judgment, the courts refrained from deciding on whether or not Security Council resolutions would supersede other treaty obligations. The applicants have argued that entering into the Delphin Agreement would be to their economic detriment and so would violate their sovereignty and self-determination. However, it is submitted that such rights are not absolute, as was adjudged in paragraph 140 of the Capchi-Covan-Hagi-Moros case, that economic growth must be balanced with environmental concerns. In events such as these that directly affect those outside of a state's territories, good faith negotiations, as already has been appraised by my co-agent, and the readiness to compromise are necessary. This right is not an absolute one. Not ratifying the Delphin Agreement and placing personal economic interests over the welfare of at least 13 other territories violates international law. Sovereignty over developmental and economic interests is inherently limited. It's an instrument to protect the relatively weak from powerful aggressors. The right of self-determination.
I'm sorry, can you answer question? What are provisions of the UNCLOS that actually force them to join the Delphin Agreement? And does this obligation actually goes from the UNCLOS directly?
Of course. So I would like to just, so first of all, the duty of cooperation as being something that is enshrined within UNCLOS is something that I've already touched on. To provide you with perhaps a more specific example, Articles 202 and 203 of UNCLOS provide for scientific and technological assistance. Within these articles, something that is mentioned is that at the end of the day, and again, reference is made to the difference between developed and developing nations, there is an obligation on developing nations to engage in agreements, in regional agreements, which the Delphin Agreement is an example of, to fulfill obligations under the UNCLOS and promote the aims of environmental conservation. So this is one example that we hope will go some extent into answering your question. Thank you, Your Excellency. I would like to conclude the respondent submissions by briefly reiterating our arguments. The applicant has breached its international duty to protect and preserve the marine environment and has breached Makar's sovereignty by fishing within the territorial waters of Makar, abusing their territorial fishing rights in a myriad of ways, as already pointed out by my co-agent. Additionally, I would like to restate that Makar's conservation measures certainly meet my apologies, Your Excellencies. May I ask for 30 extra seconds to conclude my submissions?
Yes, you have 30 seconds.
Yes, thank you, Your Excellency. Additionally, I would like to restate that Makar's conservation measures meet all international obligations. I would like to point out that there is a fundamental issue with the applicant's arguments. The Delphin Agreement, this dispute at large, it's not just about the Gelder Islands. It's about the duty to cooperate, the recognition of how activities in one nation will undoubtedly affect the other. The applicant has shown time and time again that they refuse to accept this notion, going against the international law of the sea's approach to environmental conservation. In light of such, I urge the tribunal to acknowledge the merits of the respondents, the Federal Republic of Makar's case. With that, Your Excellencies, I note my time and I conclude our submissions.
Thank you, Counsel, and I thank you to the respondents for this comprehensive exposition. I will now ask to the applicant state if they wish to exercise its right to bring up further contentions against the respondent as a rebuttal.
Your Excellency, may I proceed with the rebuttal?
Yes, please proceed.
Okay, so good evening, Mr. President. My name is Azul Miranda. I am the agent for the applicant, and I'll be exposing for the next 3 minutes the rebuttal. So the respondent argued that Makar has a much more fragile economic and could not apply measures to control the pollution. However, this claim is incompatible to the international law provisions, considering two important things. First, the ITLOS advisory opinion February 2011 in its paragraphs 158 and 159 considered that no state can deserve a preferential treatment concerning the obligation to protect the marine environment, even if it's a small island developing state. And second, at any moment, Makar requested the Gada Island support concerning technological knowledge as required by Article 266, paragraph 2 of UNCLOS. Thus, the Gada Islands could not act without Makar's manifestations. And the respondent has also argued that Makar was not required to ensure the traditional activities on the Gada Islands. However, the Gada Islands can use the diplomatic protection principle to protect the indigenous peoples whose rights are being violated under Makar's jurisdictions, as it was discussed by the ICJ in the Avena and other cases of 2004 before this court. And finally, the respondent is not complying with international jurisprudence, considering customary international law as prescribed by the ICJ in the North Sea Continental Shelf case of 1979, Your Excellencies. There is no repeated and accepted practice of the terms which emanate from the Delphin Agreement. And considering that there are no states and the Gada Islands which has not ratified the document, and even with the tribunal find it does not create any obligation over the Gada Islands, as the state is a persistent objector that has clearly and openly demonstrated in its discordance in issue a note verbally and clearly and openly opposed to the document as required by the ICJ in mentioned case. And lastly, Your Excellencies, the respondent argues that the state's conservation measures are consistent with international law and a due diligently be introduced as well as the MSI. However, such conservation measures were never mentioned in the case. And even if we consider the cleanups mentioned on paragraph 5, they are held and led by civilians and non-governmental organizations, not by the state. And just to conclude my thoughts, the respondent also argues that landfills are well managed, addressing that the only pollution of Makar comes from the Gada Islands. However, the first source of pollution of Makar comes from its own territory, reaching other states due to the poor management of landfills, which are not justifiable for their economical conditions. So furthermore, the Pacific Regional Program Fund is available for these means, and Makar did not use them. So may I thank for the time, and may it please the court.
Thank you, Counsel, for your points. I will now call the counsel of the respondent to this rebuttal if they wish to exercise this right.
Thank you, Your Excellency. We do wish to exercise this right, primarily addressing the question of not protecting the rights of the traditional fishing of the Gelder Islanders. It is important to note that Makar has implicated and Makar has contended that they are not traditional anymore. They have become commercial, in so much as the question of recognition doesn't even arise here, because we are contesting the very traditional nature of those rights. Secondly, with respect to the customary international law status of the obligations of Delphin Agreement, the guidelines regarding the waste hierarchy are essentially a regional restatement of the policies advocated by decisions 1413 of the 14th and decision 15.6 and 15.10 of the 15th Conference of Parties to the Basel Convention, which the Gelder Islands has ratified. All standards emanating from both Conference of Party 14 in particular, indicate that states must take action to move towards a circular plastics economy, something that the Delphin Agreement has very clearly stated. With regards to the same, even with Article, I apologize. Additionally, the United Nations Environment Programme in 2017 passed draft resolutions urging all countries to make responsible use of plastic while endeavoring to reduce unnecessary plastic use, echoing the Delphin Agreement. What we have argued here is that the standards emanating from the Delphin Agreement are ones that have already been stated within customary international law. So the question of persistent objector doesn't even arise. Persistent objector is only considered when they are persistently objecting since the inception of customary international laws. While the Delphin Agreement already resonates with already established customary international law obligations, which the Gelder Islands haven't persisted to since time immemorial. In fact, they have accepted these guidelines within other conventions. So the idea that they are persistent objectors doesn't really come into play, and thus we contend the objections that they have made to us. With that, I rest my time. Thank you, Your Excellencies.
Thank you, Counsel. So this concludes the pleadings in the present case. And I will now give the floor to Madame Lagraffière for the subsequent steps in this hearing.
Thank you, Judge President. So as happened within the semifinals, the team should leave the breakout room and head to the central room so that the judges can deliberate. And once the deliberations are concluded, we will let the IT team know, and you will be sent back to the breakout room. So thank you, and we'll see you soon.
Thank you, Your Excellencies, and thank you, Bailiff.
Okay, so we are back live for the transmission. And we may proceed now with the feedback session and then the results. So please, Judge President.
Thank you, Madame Gracia. Welcome back, everyone. The tribunal has already deliberated, but before proceeding with the final stage of this case, I would like to give the floor to my fellow colleague judges to give you some feedback on this round. So I call upon Judge Soto Sanchez to start this round, please.
Thank you, Judge President. First of all, I want to express my pleasure to be here, to be this afternoon with you, Brazil time, and congratulate each one of you in this extreme and hard work that you have been conducting for the last 3 days. By the simple fact that you have reached to this stage of the competition, the final, you all are winners already. That is clear, without any doubt. It was, however, we have to reach a decision, and on my position, I vote for the team that work their arguments in a way that they were fully constructed and complete. By that I mean that they express the reason and provide a linkage between their reasoning and a legal basis, either customary law, any of the sources of international law. That is very important. So I encourage you to bear that in mind for your future endeavors. I congratulate you again. It was very close, and it has never been easy to make this type of decisions. But again, the most important that I looked into in my decision was the fully construction of the arguments and the linkage. You might provide a reason, you might provide a legal basis, a foundation, but if these two are not together, if you don't provide that linkage, then we don't have an argument. We have two separate ideas. And what I look into your submissions were the fully constructions of the arguments, the rationale, the linkage between your rationale and any legal basis that you provide. Okay, so congratulations to both of you. In my opinion, they are not losers. There's a team that performed to the very best, highest standards today, and the other has room for improvement. So congratulations again, and I give the floor to my fellow judge, Katarina.
Thank you. Well, I would like to thank all of you. You're all great. You applied very well law to facts and articulated law and analyzed it. I really enjoyed this session, and I think I'm looking at the next generation of lawyers possibly working in the law of the sea, and hopefully future colleagues. So I just want to say thank you to all of you, and congratulations to all of you. Like, you're all winners for me. That's it. Judge Carlos.
Yeah, before proceeding with the result, I will just want to let you know that I also congratulate you for your effort. I was really impressed by the level of technicality that you present today. There is an evidence of legal research conducted for a couple of months, I guess. Well, it's reflected in your arguments. However, I do also encourage you to look at the organization of your arguments, follow the famous IRAC or other legal acronym to organize your argument. I think this is crucial for not only for a moot court, but for your professional career as a lawyer. This is crucial for you to order and to sound more convincing when you are trying to plead your case. So I encourage you, each of you, to work harder in this part. At a point, both teams were missing that link. You were provided with legal sources, but you were missing, and tell us or let us know why particularly that legal source was relevant for your case. So you were only dropping and dropping sources, and was already impressive. However, just try to be more concise on why you are bringing that source. So with this, I also would like to encourage you to continue mooting here in this ITLOS moot court, or in any other moot court available. I think it's a very good exercise for our profession. And as my fellow colleague Ekaterina mentioned, I really hope that we are seeing the future generation of law of the sea scholars, because many things are happening now regarding law of the sea, and we strongly require further following up by a new generation of oceans lawyers. So I encourage you to follow this path and wish you the best in your professional and academic, well, first academic and later on professional careers. Having said so, I will then formally proceed to the deliberation and the final results. So the tribunal has carefully considered the arguments presented by each of the parties, as well as the evidence. However, the tribunal has considered that the arguments of one of the parties have presented in a more convincing manner, and to have more strength in its logical function. For this and other reasons, the tribunal declares that the winner of the final round is the respondent state. So I congratulate you both, and congratulate the respondent state for this achievement. And again, I congratulate both of teams for their effort and for their achievement in this round and in this moot court in particular. I would also like to thank the organizers and Madame Legrafier for assisting us in this final round. Now I give the floor to Madame Legrafier, and I will also thank my fellow judges Soto Sanchez and Antispiania.
Thank you very much, President Cruz. Congratulations to the respondent team. Congratulations to both teams, because you have made it this far. That's a very, very special stage of the competition. We would like to deeply thank our judges tonight for giving us this really, really interesting final, to both the teams for their very high quality arguing and for being both present here today. And we will send all of the applicable certificates to your team email addresses within the upcoming weeks. And we will also announce via email the awards for Best Memorial and Best Oralist for this moot court. So we should keep an eye on the email that you have registered as your team email, as these new updates will come. So congratulations to the winning team. And with this round, we officially close the third ITLOS moot court of 2021. Thank you all for participating.
Thank you.
Thank you so much.
Are we supposed to leave?
You may leave, yes.
Thank you.
Thank you.
Thank you.